Gentlemen, unprecedented times call for unprecedented measures. I mean, what I'm watching today is something like I've never seen before. You have a prosecutor on both sides will have the opportunity over the course of 2 hours to sort of recap their opening statements and whatever they want in terms of the witnesses that were presented to the jury previously 14 months ago. Love to get your reaction to this. I'll start with you, David.
Well, it is unprecedented, and what's fascinating is that it's a 14-month recess. But I looked at some law because I knew I was going to be on your show, and there actually have been some very long trials. One of them was the Hillside Stranglers right here in LA back in the 80s, and another one was the McMartin trial, which was even longer. But the Buono case back here, the Hillside Strangler, was especially interesting because the trial lasted 2 years. Not trial preparation, Mike. The trial lasted 2 years. The star witness in the case, the cousin of Buono, a guy named Bianchi, was on the stand 6 months. The argument was that a jury could not retain such testimony for 2 years, for a year and a half, and yet the case was affirmed. So that leads me to believe that the judge is on firm ground, not impaneling a new jury, legally not delaying the case unless Durst has really terrible health problems to the point of being basically incompetent to pursue the trial, in which case he'll probably be remanded to somewhere to deal with his incompetence, which is not the remedy that he wants. He wants to get bail. So to put it simply, I think that this trial is going forward and will legally be allowed to go forward, and that the jurors from 14 months ago will be able to retain the information from 12, 13, 14 months ago. But to make sure that they retain it, they were allowed the prosecution to make this opening statement that is not only a normal opening statement, but that recapitulates all of the testimony that was from 13 or 14 months ago. That's why it was so long and detailed, unusual for an opening statement, but one necessary after a recess, a suspension of 14 months.
David Katz, I think the reason that he's impugning the victim in this case is because she's doing some things that are not so nice. She's keeping information from the police. She's supposed to be aware of this crime and not telling it. So for this jury to understand why someone like her would do that, they need to understand her background.
Well, I think what I'm going to be really interested to hear on Court TV, on your show, is when they explain exactly what it was that Miss Berman was supposed to have done to help cover up the murder and what it is that she really had on Durst. Because I agree with Brian's point that, of course, this is impugning their own victim, and you don't need to really go there in a murder case, but they're going there. And it must be in part to take the zing out of whatever the defense has on Berman. Because remember, Durst knows her inside and out. He knows every little thing that she did wrong. And they're going to probably, put the victim on trial during their defense. So, part of it is to defang that defense, what the defense is going to do. So I think that the opening statement was in a great deal of detail. I think that they're going to run the risk. Can they really produce evidence to back up everything in the opening statement? But I think the judge has allowed them to go down this road. So I think part of what the prosecution wants to do is to lay it all out there and to make sure that they've, relying on the judge's ruling so far, have put all of this hearsay, all of these things that could be more prejudicial than probative, they put it all in the opening statement. So if the judge starts to get cold feet later on, they can say, well, wait a second, Judge, you said it was okay, and now we've gone out on this limb. We've laid it all out in the opening statement, because this is much more detailed than I'm sure that Brian or I would do in an opening statement in either a civil case or in a criminal defense case.
And I agree with you 100%, but let's remember, this is actually less of an opening statement and more of a recap of what happened the first time around. So I think the judge is giving them some leeway in some of the statements, because as Brian mentioned earlier, there's all sorts of hearsay. That's why I didn't even mention it. There was so much of it. And, some of the statements are going on and on. So I think the judge is giving some leeway there, but you're absolutely right.
Michael, let me say one thing, though.
Sure.
The judge let it in 14 months ago. 14 months ago, they could have made hearsay objections, and the judge let it in. You'll notice on one of the transcripts, they had something blacked out. I assume that was because the judge did not allow that to come in. but they're going from a transcript from 14 months ago, which is testimony that the judge allowed in, whether it was hearsay, whether it was opinion. He overruled the objections if they made them. And now that he's gone out on that limb, the judge, the opening statement by the prosecution and the recap, they want to make sure, okay, we trotted it all out. Look how prejudiced will be, Judge, if you now go back on it. We've laid it out in front of the jury based on your rulings, Judge. So I think that's part of what the prosecution's doing in the opening statement and in the recap here.
David Katz, and David Katz, I'll start with you because I know you've tried some cases in that area. When one looks at this situation and you have an illegal immigrant in court, of course we know all the constitutional protections provided by this country are available to illegal immigrants when they're in our justice system, but one still has to worry about the possibility of a really fair trial for someone in his situation.
Well, I may sound like Pollyanna, but I tried two cases in the Midwest. Now, both of them were in federal court. And the case in Omaha, Nebraska, I had an African-American defendant. We had 12 white jurors, no African-American, no Hispanic. And I thought they were very fair. Of course, I thought that because they acquitted my client. And there wasn't as much evidence against him, I must say, as there appears to be in this case in Iowa. And then I tried another case that was also in the Midwest. That was in Sioux Falls, South Dakota. And again, you look out there and you think, well, maybe there'll be a Native American on the jury. Maybe there'll be a Latino. There wasn't any of that. Again, you look out, there were like 12 white jurors. I'm there with a Hispanic defendant. They were not allowed to get into the immigration status. I don't think they ever are in any of these cases nowadays. They certainly aren't allowed in California. But again, the jury was very fair. He was being charged with dealing in drugs, and he was convicted only of being a money courier, which meant that he got less time than all the people who cooperated against him, who were all white and who were from that community. So I guess I'm here to say that I think the jury really will be fair. And even though there's one Latina, even if the Latina lady that got on the jury, even if she's only an alternate, and he has an all-white all non-Hispanic jury, I really do think that they'll be fair and they'll try to be fair. Having said that, they found a body. They found blood from a body, right? DNA from her body in the trunk of his car. And unless he has some kind of a defense, I just think that he's definitely going to be convicted. Now, what degree of murder it may be, that may be what the defense is really trying for here. And on the Miranda ruling, the judge seems like he was absolutely right. I mean, if you leave out part of the ruling, of course, you don't get the statement in. That's the whole purpose of the landmark Miranda ruling. And if you don't say that it can be used against you, and you don't translate that into Spanish, I mean, I'm just amazed because ever since Miranda, one thing that all cops and federal agents had, they had their badge and they had their Miranda card, which laid out in English and Spanish how you give the Miranda warning verbatim.
Yeah, no question. And Brian